This is Family Law, and it is March 7th. And we're taking up basically a continuation of the child support question that I raised last time, or I raised on your assignment that was due today. We're also going to cover the Galloway case, and I'm going to give you some guidance a little bit on the next chapter, and that next topic that is really not, I don't know, it's complicated in a general or in when you actually apply it, and but it's the concepts of it you need to know are pretty simple, and that's the tax consequences of marriage and divorce, which people love talking about tax, but they also rely on people in the legal field to give them guidance on all that, because tax is really a law area. So the first thing is, I asked you a question about child support, basically continuing the George and Susan scenario, but I changed the numbers a little bit around so we could think about, after their divorce, how much do we owe in child support? How do we make those calculations? So I sent you out on your way to answer a couple of basic questions, which I think should be somewhat manageable in the where do you find the answers, okay? Now, I'm showing you currently a basic shared parenting worksheet that helps you determine the amount of child support, okay? Now, you're fortunate in that I created this. This is my own creation, okay? The document itself, it's an Excel file. However, I didn't make it up, right? It exists somewhere in the universe. Did you find this worksheet somewhere? Okay, because I asked you specific questions about this worksheet, right? I said, you need to tell me this line and that line and come up with some of these numbers, right? So it sounds like you're doing calculations, but really you're inputting some information, and this whole worksheet tells you how much is it that you have to pay in child support. Okay, so where do we find this worksheet?
It's West Virginia statute.
Okay, it's in West Virginia Code.
Yeah, 48.
48, 13, 301. So you find this worksheet in the statute, right? It just pops right up. There it is. It's not too hard to find it, I hope. There's actually the article of it is called like calculating child support or something to that effect, right? Well, I mean, even that, when you go to the link to that article in the code, it's like calculating child support, right? There's another item, another line that talks about, you know, what is child support? What does that mean in a more general sense? How do we determine how much that is? So I give you this scenario, and then there's lots of in-depth questions that come out of this little fact pattern, right? So the first thing I asked you is, under West Virginia law, is the arrangement a basic shared parenting or an extended shared parenting? All right, so first question out of the box is, why is that important? Why do we need to know if it's basic or extended?
Because whatever you answer is going to be the worksheet that you use to, get the rest of the questions.
Okay, so the answer then leads you to the correct worksheet, right? Okay, so that's what we do, is then we determine, is it basic shared parenting or extended shared parenting? Well, what's the answer?
Basic.
Okay, it's basic shared parenting. How do we know it's basic shared parenting?
Because George has less than 35% a year.
Okay, so what's our first step, really? Defining those two terms, right? So you found that you've come to the answer, you figured it out. How do you know it's 35%?
Yeah.
It's what?
127 days is 35%.
127 days is 35%. So you know you're looking for that number. And then we look, I give you it, I tried to make it as fairly simple in terms of how you figure out the actual overnight. It gets way more complicated because typically a family court order will say you get every other Friday to Sunday And then it doesn't discount that there's, 26 weekends in a year, basically. It doesn't discount the fact that you get some other weekends that apply in, like a summer break where you discount a weekend. I give you that anyway. So basically I put in there for you with a number of days, and you just really had to add them up, right? And when you add them up, you come up to what number? Like 78, 76, 78 nights, overnights that George gets. So then how do we determine what the percentage is of that? We divide the number of overnights he gets by the number of nights in a year, right, to get the percentage of overnights. Oh, this stinking math comes up. You thought, oh, there's no math in the world. We don't, that's just something that math teachers came up with to punish us, right? They just wanted to teach it to us, so they came up with it. Well, that's what, unfortunately, or fortunately, one way or another, this is part of the job. I mean, it looks like math, but math's part of law it's certainly in this circumstance. You would clearly be asked to do something like this. Luckily for most of us, the Bureau of Child Support Enforcement does most of this. They have nice worksheets. When they put the numbers in, it automatically populates that thing we mentioned earlier about where it comes from the chart. There's a program that pulls the chart, and as soon as you put the combined income in, you get the number, okay, the basic obligation. So anyway, you find out that if you're over 35%, or if you're under 35% overnights in a year, if one parent gets less than 35%, we're automatically on basic shared parenting, right? We're not on extended shared parenting. Okay, that's a good thing for us in terms of doing our math here, right? And so I asked you to provide the citation to law. How do you know? What's the citation? It's in the code too. Hopefully you found that definition between those two, okay? So then I asked you, based on your answer to A, how much is the basic obligation? All right, so if you look here, what is it that we have to do to come up with the basic obligation? Number one, that's number 4 on my sheet, right? So I've given you a couple highlights. We need to figure out, what is the mother's monthly gross income? I told you it was $45,000, right? So what's her monthly? We have to divide that some way, right? Okay, so we get hers is $3,750. George's, he makes $40,000 a year. What's his monthly income? And we don't really need to worry. And then IRS doesn't worry about the things after the decimal point, so neither we won't too much. Yeah, we just keep going on in oblivion, right? So look what happens. It generates this in my form. I just generate the combined total. Why? That's important for us, right? Use line. So we get the monthly adjusted gross income. Yeah, if you don't do taxes, you probably never heard. You don't hear those terms very often, but AGI is an important term in tax. Adjusted gross income, because that's actually what you pay for. That's what the number that they use basically to determine your taxable income. That's one of the most important terms in income tax law. Okay, so we come up. I know looks like this is just terrible math, and it's figuring out these numbers, but it shouldn't be that difficult. There are some things that you might subtract out. None of those apply in our case, but the first one is your minus your existing child support payment. What that means is, if you remember, we talked last time briefly about the fact that if you have a child from a different relationship, the first one gets their own, they don't have theirs reduced. Okay, so if I'm the child from a first marriage and there's a child support payment, and now we're here calculating the second one, we would put that pre-existing payment in these columns. Okay, in the mother, if the mother had it, the father had it, we might indicate then we reduce that monthly gross income by that, because we realize their ability to pay, it's all based on ability to pay. We would subtract that out. There's some other things. I think the one that you'll see that's commonly discussed is this overtime compensation, and you see that you don't get. There's some exclusions to overtime. It depends on how often. Some people are always working overtime. It's like actually part of their, really truly, it's part of their base pay. People that work in the prison system, for instance, a lot of times it's like really that's their pay because they work way over 40 hours a week every week. Different employees, but sometimes that isn't excluded. A lot of things are. If it is, you only really get 50%. You only calculate 50% of the overtime compensation into it. But anyway, none of those are there. Additional dependence deduction, there's all those numbers. We don't need to input any of them. So our numbers at monthly adjusted gross income is the same. You see that why it's now adjusted is if any of these factors play in, we then reduce it by that number. Okay? Why do we care? We want to get to a combined number because we need this combined number. We also need to know what are the percentages. Well, I just took the percentages here using a calculation in Excel. Okay? That's how I did it. But we get 53 and 47% of the basically that's the percentage of the income that would come into this household if it was still together. Okay? That has to equal 100%, by the way. If it doesn't equal 100%, we have a problem because you can't have more than or less than 100% that's combined. Okay, so now these are really some of the most important numbers we're getting in terms of this whole thing, right? We had to generate those numbers in order to do what? Apply the statute, right? Okay, so what do? At this point, we need to come up with what is the basic obligation. We take line 2, and we come up with the combined income of the parties, of the family, right? That's what we do. We come up with the combined. We go to the statute, and we know what else about them. There are 2 kids. Okay, so let's go ahead and see if I can not screw it up too bad. West Virginia Code. I better share that. Hey, we're here. Okay, I'm sharing West Virginia Code a second. We come into the West Virginia Code, and we're going to go figure out if we have 2 kids, and we have how much income was it? You remember? $7,083 was our combined income, right? That was a question I didn't wait for the answer. And we go down and we figure out that the guidelines for child support, which is Article 13. And if we scroll down a little bit, we're going to get to this big fancy chart that's the monthly basic child support obligation. Okay, so we know it's 2 kids. We're just going to go apply a chart, right? Again, this is math class. I know it's painful, but it's math class basically. You go down this chart. Here's our monthly gross income down on the left-hand side. Okay, and we're going to go to $7,083. Okay, so $7,083. What do we not have? We only go by 50. Why do we go by 50? Because that's when it hits the next dollar amount, right? So we're over 7,050 and we're under 7,100, which means this number applies to us. So we do this. We take 1194, right? That makes sense?
Yeah, I rounded up
to what?
1,200.
Oh, you went to the net?
Yeah.
That's fine. We can do that too. I don't really care. As long as I don't have to pay it. Okay, so we went to, how much was it? Ended up being 1,200. I put 1,200 in this box. And that's our basic obligation. Okay, now what is that basic obligation really telling us?
Telling us like bare minimum amount of money that the child needs to, live its normal life.
Okay.
2 parents are responsible.
So if it's 2 parents, that's how much money is involved, right? So basically, we're giving the kid, if we think about it in the more general legal principle, we say what? We say that they get to share in the lifestyle they would have if the family was together, right? That's the general principle that we know of, but how do we put it in numbers, right? Well, we just come up with it. Hopefully they've sat down and discussed what that means, right? So we get 1,200, and we take all of those numbers together, and we take that 1,200, and then there's a whole bunch of things that we could adjust it by, right? That's good. Whatever, however, none of those applied here. So we add line 4 and line 5E to combine to get what is the obligation amount. Look at it. Some of this stuff we add in because now the household's not together. We're going to say some of the child care expenses are actually support. Some of the medical stuff is support, right? We're add those factors in. We won't here. So what is the total support obligation? How do we come up with it? So I ask you, who is the payor parent? George, right? He's the one who has to pay. How do we know it's him? Because they reside with her. He has less than 35% of the overnights. So we just know he's the payor. So we're going to come down here and we'll say, as the payor, I think I have a calculation wrong in this box, or I didn't put it there. And how do I decide what the total support obligation would be? With no changes, it's still this, I think. Right? Okay, I take that, it could be changed. And then how do I get that he's the payor? How do I figure out how much he has to pay? What is the recommended? What is their share of that total? That's basically, you could do an Excel calculation that calculates this. Okay. And this, right? And we get, well, it didn't like when I put. I know this is like that class you all hated, so. Right? Excel. So then we get, this is the total share, and we say how much is each one contributing to the child's welfare, basically. So we still factor in the part that the mom, some of her money goes to support the child, right? It makes sense, obviously. But we put that in. Then what do? We take the dad's number and we put in basically this, and we figure out that's the recommended child support order, right? Everybody figure that out. Hopefully it's less complicated now than it was while you were thinking about it. You just have to add them up. Basically, that worksheet kind of puts the numbers in as long as you find the right inputs, right? And then we have to do math. There's also another piece that plays in, and it has to do with the ability to pay calculation. And that comes in really only if you make under $1,550 a month. Then we say, we're going to give you some self-support income, basically. Okay. Usually that's at least $500 is reserved that you can use for your own benefit. Remember, we talked about that a little bit with George and Susan in a previous thing about alimony and whether it's fair to have Susan pay more than basically half her income to George. Okay, we don't know that that's accurate. Well, in the child support calculation, because it's already pre-done, the law says, yeah, you get some self-support if you make under a certain amount. Okay, so there's my form. I'll share that with you in case you ever have some interesting need to use it. Okay, hopefully you don't, but generally BCSC provides that. Okay, so then I've asked you a couple other questions, and I think then that one's fairly simple. But which calculation is more complicated, the basic shared or the extended shared? Why is extended shared more complicated?
Multiply the amount that you get in basic by 1.5 equal the extended shared.
Right. So you have some calculation that's added in to count for what? What does it really account for? You multiply it by 1.5 to take care of some differences in the way we're parenting, right? Brian always quick on it, says this name is not basic, so extended is more complicated, right? Okay, I agree. Extended sounds more complicated than basic. It's like an obvious question. But what's the reason? Go ahead. Yeah, so if you increase the amount of overnights at the other parent's house, it starts to become like, well, because I have a child, I have my kids, more nights and more days, more of my income is getting put into taking care of them when they're at my house, right? Makes sense. And so that's what the big difference is. Really, it's more complicated for that reason alone. It's that you are already putting in money towards their support, the more often they're with you. At least that's is that pure as it can get? No, not really, but that factors in. Okay. All right. So then I asked you a couple other questions about what is it. You can always modify a child support order. Okay. And basically there's a general rule about what that means. And then there's a commonly used rule of thumb about when you can create a modification of child support. Okay. So what is the general rule for modifying child support?
Basically, whenever a motion is made that alleges a change in circumstances of a parent or another proper person.
Okay, a change in circumstance, just any change, or does it have to be a certain change?
It has to be a certain change.
A substantial change. So a substantial change in circumstances. Okay, why do you think the law creates that terminology? Why do we use substantial versus a change, just a change?
Didn't have a substantial change, then every time somebody had changed it.
Right. So every time there was a change, you could get another modification filed. Okay, give me some example. What are we talking about? We're talking about people's income. Does income move? Yes, right? The monthly gross income, especially if you start calculating overtime, and then some folks are laid off for periods of the year of all the time, it could be changed all of the time, right? I get a raise at work that's maybe not great. It's 25 cents an hour. It's not nothing, but is it really a substantial change? Did it really change much for me? No, not really. I still basically make the same amount of money. Usually when you get like one of those raises, it pretty much offsets or less than offsets some other increase in expense you have, right? So that's what always happens. It's like not the greatest change. So we need that substantial change. Why? Because we're trying to break these parents away from each other, partly. We don't want you to come back all the time and discuss endlessly well, I know he or she makes more money now, or they quit working on purpose, or whatever it is, right? We realize there's a lot of conflict that arises in family law that can make it complicated. Okay, so substantial change in circumstance, was that basically the law in Ohio and in West Virginia? Yeah.
It's 15% West Virginia, 10%.
So the automatic number that we assume or we consider it a substantial change in circumstance in West Virginia, it is how much?
15%.
15%, and in Ohio it is 10%. But does that mean that's the only time you could get a change? No, it doesn't. It actually, there's another provision. It just says that we assume that it's a substantial change if it's more than 15%. That's the easy way to think about it. If I would change the child support obligation by 15% in dollars, that's an easy way to make the decision, right? But there's still going to be a substantial change because of custodial arrangements, different child care scenarios, and all those things, right? Okay, so I just wanted to raise that and put that out there for you, so you have some concept of that you're still going to have change even without the number. Okay, let me share with you another thing. Okay, I had you look at the Galloway case. Okay, I think this is an interesting case because it lays out some interesting principles that we don't always think about. But it's also kind of a hot topic case, right? In the Galloway case, what's going on generally in the Galloway case? We could call him a name. Okay, we won't. Let's not.
And there's the attorney working on the case too.
Okay, who was the attorney for him?
He was a plaintiff.
He was the appellant. He was the petitioner. He was the appellant. And she was the respondent. Michelle Reardon, right? She's now the public defender. Okay, she wasn't always that, as you can tell. And the repellee is represented by legal aid, right? And Catherine Adams is an excellent legal aid lawyer, or lawyer, period, and she does legal aid. Kind of interesting case. Couple other things you could note is that this comes out of Wood County, right? One of our judges, and it's a per curiam opinion. Have we talked about what per curiam was? I think we have maybe in different classes, but in this class, it means it's an unsigned opinion. No one in particular wanted to put their name on it, but at least the majority decided that was true, except for the Chief Justice. He writes a concurring opinion, okay, and he files it, and I had you read it. I hope you read it too, because it's an interesting little bit of a discussion. Concurring, again, means that he agrees with the result, but he wants to say some other things. Sometimes it's like they agree with the result, but for different reasons. Sometimes they do it because they want to explain something. They wanted to get it off their chest or whatever it was, or clearly indicate it was their opinion as opposed to the opinion of the court. Realize, even though no one signed it, someone wrote it. And a lot of times, actually, if you're active in the court, you'll know who it was because of how either how it's written sometimes, but how the assignments go. You can kind of get an idea because they will deliver them all about the same day, and it usually comes out of one justice's office when they're finalized. Okay, but so I want to go back. It's a per curiam opinion. No one really wants to say anything in this case. Why don't they want to say anything in this case? Publicly, they don't want their name on this case because of why? You have a clear non-biological father being ordered to pay child support, right? That's what you have. Is that a popular position to take, do you imagine?
No.
No, it's not. They're always going to say there was you shouldn't have done that, right? Okay? This is a difficult case for that reason. But there are lots of facts in underneath this one, right? Okay, so I want to point out something that's really important in this case, and that is that the family court denied this guy the opportunity to present DNA evidence for the purpose of disestablishing paternity. Okay? That's a legal concept, isn't it? So factually, we know he's not the father. Legally, we're going to call him the father. He's been called the father. He's the legal father. Why is he the legal father? Before we get to the end of this case, at the time he is the father. How do we know he's the father? Okay, I'll give you the first one. No, not adoption. The couple were married, and 2 months later, the child was born. Okay, a child born within a marriage is assumed that the husband is the father. That's the first way we know. Okay, so that's the first one we know. Marissa points out the second way we know. His name's on the birth certificate. Okay, so we know for 2 reasons that he's the father, because it was born within the marriage and his name's on the birth certificate. Okay, there's a third way which we're going to find out comes out of this case, basically. All right, so what we have is they're married. She's already pregnant when they get married, because then the baby's born 2 months later. She gives birth. 3 months after the birth, okay, they've been married about 5 years. She says, it may not be your child. Okay, after that, they go to DNA testing, and there's a report that confirms he is not the father, right? What happens to him at that point? He continues to live there as the child's father for another 14 months. The child's now 2 years old, starting to know who dad is, right? He continues to live there, okay? Yep, he stayed another 14 months after he knew it wasn't his child. They file for divorce, they raise it in court, they even have a guardian ad litem go out and do it. What happens? They don't show up to the final divorce hearing, and they dismiss it. So it was like going on, and we were going to be done in 2000, but it's dismissed because they don't show up. And then what happens in 2003? Now we're 2003. The child's born when? In 98. So now we're getting to be, the child's got some age on him. What else is interesting about what the child, where the child spends her time? She spends time with her mother, or with his mother, right? She's grandma. And then, and sometime in 2003, this is kind of an interesting point, and Marissa points it out. I thought it was weird that he asked the child to stop calling him dad after the amount of time he was in her life. Yeah, that's where actually that gets put out there in the facts. That also gets put in a footnote in the case. They mention it again. And they really point that out. And the circuit court, if you've seen the circuit court order, it also focuses on that is a tough thing to do, especially while the child is still going to your mother's house, right? Her grandmother's house. So a lot of people, that's an issue that comes up in the case, right? I mean, that's where you get the, Brian points out, that's when you say that's his jerk at that point, right? We start to have different names, but we also feel for him, don't we? Do we feel for him at all? No one does? Not about that issue, but in this whole issue.
No.
Okay? Alex says, yeah. Tara says, absolutely. No, those all came pretty quick. Brian says, maybe. Okay, the two here, I'm not sure. William hasn't totally given me an answer. I know Peggy's answer is no from what her facial expressions. And I feel for him.
I kind of do, yeah.
I feel for the child.
Because at the same time, the mother, she had to have known that there's a possibility that child wasn't his. And she waited until how long to tell him?
Well, at least we'll go with around 7 months of the pregnancy. She knew before they got married, right? Not before the pregnancy. She was pregnant, right? She doesn't really say that it's not yours until after the baby's born, and really then 2-3 more months later, then she says, ruh-roh. And guess what? You notice this? That this divorce proceeding is delayed awaiting the results of paternity action in Ritchie County, in which a man named Michael Stevens underwent paternity, and he wasn't the father. And then, in the end of the case, we find out there's a third father that may be in jail. Potential father. So we still don't feel bad for dad?
I do.
I don't really, because he had a choice in the beginning to wait until that child was at the age where she recognized him as the father. It would have been cruel to fool him. I mean, for him to tell her, don't call me daddy, was kind of cruel to a child that he was a father to, whether he was biological father or not.
So what Peggy says is, yeah, you're starting to become a psychological parent when the kid's now, 4 years old. That's when you decide, when you say, don't call me daddy anymore. Yeah, I mean, I think we have an issue there, but we can still feel bad for him, can't we? We're not comparing him, only when we get into the problem of calling him against the child, right? We don't feel bad for him compared to the child, do we? I'm asking.
I feel bad for him in the fact that she, the way she did, but the child was the victim in all of this.
So do we feel better for him than we feel for mom?
You don't want to know.
Yeah, I'm with you there. The mom is a shady person.
I mean, the child
There's some things going on underneath.
It's called selective parenting.
And Tara points out, or Alex says, I feel for him. I don't think you should tell her to stop calling him dad. However, it's not his fault that the baby isn't his. That's right. It's also not the kid's fault about what the parents have done, which is what Tara says. I feel bad for the child alone. she shouldn't have to pay for the parents' mistakes. I absolutely agree with those statements.
Haven't these people watching these soap operas? That never works out.
Was it
So there's a lot of complicating factors here, but again, factually, we know he's not dad. He knows he's not dad pretty early on, but he's married now, and he apparently really loves mom, right? Or it did. At some point, that breaks down, but for 14 months, it looks like he loves mom, right? He wants to be with mom. Doesn't necessarily mean it means he wants to be with kid, right? With daughter. I'll tell you another reason I feel bad for dad is, you notice anything that's different about this case than like the other cases in family law we've seen? We know these people's names, right? We know them. Tiffany. We always know their first names, or a lot of times we know their first names. We don't always know their last names, right? We know all three of these people's names. And we know this other guy in Ritchie County's name. In family cases, we almost never know this, right? That's pretty public thing going on.
Richie County, why doesn't that surprise me?
Ivy, we would usually not know the child's name at all. We would usually have known that person as IG.
That's what I was surprised.
Isn't that interesting? I don't know why they did that. Even a case they cite to repeatedly, Michael KT versus Tina LT, right? We get those other factors. I don't know. I'm surprised. I don't know why they did that. No, parents cannot agree to have minors' names. Good question. They can't. It's not their right to do it. Only in this kind of a case. Usually the court just decides that, to protect the name, to protect the people. Okay? So anyway, we got some tough facts here, right? But we have one that looks more and more to me open and shut, and in full disclosure, I'll eventually tell you why I know that. To me, I feel that way. But they lay out the Michael KT factors, the 8 factors about whether we should allow you to disprove paternity. Okay, that's legal posture. We're saying we know he's not dad, but are we going to let him not be dad? Right? What is the number one reason people say that courts do that? Well, okay, but what? I mean, not the courts. That's what the court's going to say. Monetary support. You just want me to pay, right? That's the criticism when courts do what they've done in this case, is that it's all about the money. You don't really care if the kid has a parent or not. You just care that somebody's paying for the kid, right? That's a pretty tough criticism, isn't it? You can imagine there have been cases where that's true, right? That's what it's about. But I'm just pointing that out to say that's what a lot of people say. So the court, though, tells us there are 8 factors that come into play. The first one being the length of time following when the putative father first was placed on notice he might not be the biological father before he contests paternity. Okay, that's a pretty big factor in this case, isn't it? Do you all agree that that's a good factor for the courts to rely on? Remember, I know I might not be the father, but I don't quit. I keep it going. I'm putting myself out as father. It's a pretty big factor, right? Okay. We ask then why? Didn't you then take on the role? Let's go with it. Psychological parent. Didn't you willingly enter into that arrangement? Probably so, right? Okay, the second factor, length of time, basically when you held yourself out as dad. Okay? The third, the facts surrounding the discovery of the non-paternity. I think what they're saying there is what's the level of fraud or some kind of dishonesty or whatever that happens to conceal it. That might be a factor a court can consider. The nature of the relationship between the parent and child, the age of the child, the harm that might result if paternity were disestablished or disproved. Right? That's a big factor potentially here, which you see. Okay, the extent to which the passage of time reduce the chances of establishing a different person to be the parent father. Okay, all other factors which may affect the equities, we always have that one thrown out there. And we always know there's one other that they don't even mention here, right? The polar star principle. Best interest of the child is always the polar star that's followed in cases involving children. So that one's always out there too. And guess what? They lay that one out there. And the family court ruling says, well, you shouldn't disapprove, but unfortunately, the family court doesn't go through the factors. Luckily, the circuit court does. They go through all the 8 factors and explain how they weigh one way or another. We get some procedural nightmare things where the guardian ad litem doesn't present a report. Common, that happens, but it sounds like a good argument to make. Okay, I'm moving down to say the analysis, and we say, when should we refuse to allow this evidence that we clearly know is going to disestablish paternity? Here's the polar star principle. And we also look at this, which I think is the polar star in a case like this. The law favors the innocent child over the putative father. Right? So we feel bad for dad, but we only feel so bad for dad because we're really worried more about the child. Right? You agree with that? So then we state, anyway, you get some factors that come in here. Basically, we should do it sooner than later. And we basically don't allow you to bring in this evidence if it's been more than a relatively brief period of time. So we want it to be established. And why do we care about how long it's been that you've been the parent?
I can understand minors, but what about these cases where people don't find out until 20, 30 years later that they're not the child of someone they thought they were? I mean, I know that child support wouldn't take place in that example, but you would still have to legally prove, for document's sake, that you're not the child, right?
Okay. So the question basically is, what about those people who go into adulthood and think they're one person's child and turns out they're not, they're someone else's child, right?
Yeah.
Which we know of those cases, right? And I think if you, and Alex points it out, I think that by that point, the parent is their parent. That's this concept overall, right? That legal versus, biological, it doesn't always mean the same thing. So we have it from the law's perspective. First of all, what comes with support and all that stuff is that we have well established that those kinds of periods of time are so long that you really have established this legal parenting. How do you resolve it, you mean, in terms of like legally making it clear now I'm someone else's child? Is that what you're asking? Yeah, that does get to be difficult. You probably could undo a birth certificate, because you can have that done, where you can then change the name on the birth certificate, because we presume that a child born in a marriage is a product of the marriage. And we presume that if you're on the birth certificate that you're the parent. Those presumptions can be rebutted if the name on this birth certificate is changed, even if you were born within a marriage. So it can be rebutted, it's gone, and then it would automatically, you could make it change in that way. It depends. At that point, are you going to say that you don't want to be that parent's child? Those get to be more complicated questions, right? Like, I would much rather not have been associated with this person. Those are complicated questions. Hopefully that's not a common situation, but it's not uncommon at the same time, right? So good question. Now, how do you resolve it? What if you have a person who, their parents are divorced at age 10, and now they're 30 and they find out they're somebody else's kid, and from age 10 to age 18, dad paid child support to a kid that wasn't their own. Do you think they could change that? Probably not. We're not going to undo those things, right? For really the same principle. Yeah, good question. Can dad request to be paid back? I doubt it. For the same reason that we would say you've been a psychological parent, you've assumed the role of being a legal parent, you have done the things that society says are good. Those are not bad things. that even if someone else doesn't step up, you did, right? That's a good thing. We want people to do that. We want people to be parents. It goes beyond genetics about whether or not they're good parents. So the legal parent would not have to do anything. You mean in terms of undoing, the biological parent. They wouldn't necessarily have to do anything, yeah. There wouldn't be an obligation out there. Those are complicated circumstances. I'm sure there are cases on it that I haven't seen, though, where someone has sued.
You know, that might be like a civil suit.
I think where you could maybe, but you'd almost have to probably prove fraud on behalf of the mother in order to get some recovery. Maybe there's some other grounds that you can bring forth on that. That's a good question. That would be a civil suit, probably wouldn't be a family lawsuit. It's certainly arising out of a family lawsuit. So good questions. I don't know the answer. I wish I did know the answer on that. That's a tough one. But just keep that in mind, that those might be out there. Yeah, it doesn't seem fair, but at the same time, I mean, being a parent doesn't just mean biological, and biological doesn't mean you're a good parent. I mean, it's the same, it goes both ways in some cases.
That's another thing with this, telling her not to call him daddy, is he being nice to her?
I know, we don't wonder, so the question was, is he being nice to her? Well, we don't know, but it sounds a good bit like grandma is taking care of his time with the child. Okay, grandma was really always grandma. She never changed her position, her role with the child, which is really an excellent thing that happened and for this kid. So I think his only real interactions more or less had to do with time that the kid was with his mom. So I don't think that he necessarily had. So how did that come up? It certainly was not good for him for that evidence that he was saying don't do that anymore to come up. That probably came from grandma. She's probably the one that overheard it. I don't know that one to be sure for true, but I'm guessing that's where that arose, because I don't think that between mom and dad they were having any interactions at that point. Okay, so you see all the factors and all those things that happen in this case, and basically they determine what? It's in the best. It's really the opposite of the best interest. It's that it's not in the best interest of the child for her to not know who her father is. Some of the reasons for that are, it's been a long time. He held himself out as dad for a long time, even after he knew he wasn't, right? Those are pretty big factors. And the other, this is the one that sometimes burns people, that it will be great harm to the child if she has no legal father and has not provided any support, financial or otherwise, from such legal father. We also know it's very unlikely at this point, she's now 10, that anyone else is going to be determined to be your father or ever take such a role, right? So that's a pretty big factor, isn't it? Do people like that one? Like she won't get financial support from a father? Yeah, the case went on for 10 years. That's the other thing. A long time. So that's the one that sometimes burns people, but they say, well, shouldn't we give stability to the child? Isn't it the child that's really at issue here? It's really not the parents. We can't care about the parents that much in this case. We try, but we have to care about the child first. The child is innocent. They did nothing wrong. So that's a good point too. Tara points out that it can be easier to not have one than have one walk away. I don't know. This one, at least we know that this one has a grandma that's involved and some of those other factors, but they're out there. So I will tell you that I wrote the circuit court opinion in this case, not the Supreme Court. So I'm the one who did the factors. I applied the factors, just if you wanted. That's how I know about the case, for one thing. I wanted to talk about this one, the concurring opinion, really quickly, because this Justice Benjamin wrote this specifically. he concurred to write some things that I think were interesting. And one of those is that the main thing he says is you got to keep in mind that this is really not about mom and dad. It's about the kid. Ultimately, that's what he's saying. We concern ourselves with the child's interest and welfare. Okay? That's it. Part of that is financial support. Yeah, it's not something everybody wants to say, that it sounds like you're just trying to get money, but it's part of it. But realize this, he says it, that lives can be messy, especially when relationships fail, right? He also says that one of the parties here was clearly deceptive. While dad may not look like the best guy in the world, mom isn't looking that good either, right? So he writes all that in a really nice way, doesn't he? You know, in a true justice-y way. Writes basically like neither of these parents are in really good stead here. Remember, it's the child. And the other thing is this law doesn't really need change because technology now exists. Okay, and this is going back in 2009, I believe. He says basically you can go to the drugstore now and get an idea whether or not your kid without going into, get some idea if there's a question. And so that it's easier to determine those things, and that the longer you delay finding out for sure, when there's a question, I don't think they don't think the justice is indicating that we should distrust our partners. I'm certainly don't believe that that's what he's looking for. But that if there's some question, we would push it out there. We have to look at a lot of things, and the fact is, this is this child's only known father. He should step up to the plate, and we should encourage other fathers. See, do you think that this guy's going to get actively involved in the child's life when this kid's now age 10, assuming he wasn't really for the last 7 years, 7 years? Do you think he's going to get active? Probably, maybe not. We don't really have a good answer, except that shouldn't we be clear in encouraging other people that they will have this responsibility in a similar circumstance? So that's what he's saying there. I think it's kind of interesting. So anyway, interesting case. I think in terms of the different factors that play in child support cases, because that looks like that's a child support case, really not a child, whatever the other kind of custody case is. Okay, any questions? Related, very related. Okay, now let me look and see if I can pull up that outline. And of course, it's not there. All right, any questions? I do want to say that the keyword for this day is, adjusted basis. Adjusted basis, like BASIS is the term. It's a tax term, actually. Let me see. I was going to take a picture of this outline so that you could even see that. Hold on. It didn't pull up on my shared folder, so sorry. I took a picture of it. I'm going to put it in. I don't want to rate the app. Okay. Oh, how about this next? We can see us. All right, I'm getting it back. I think. There it is. Did it really look clear? I didn't know. I'm paying attention. Or are you just being smart? Because I can't tell. Oh, good. It's a pretty good camera, yeah. Thank you. I didn't make it. I Googled it. I went and online, I said, what's the best camera for most people? And that's the one that came up. Truly, I do that with a lot of things. I don't have time. All right, so here's my, luckily I printed out my outline for this so we could go over it briefly about tax consequences of separation and divorce. And let me tell you 3 basic things that you need to know. I know it's all in there. This is tax. It's not everyone's favorite thing, but there are factors you ought to know because I'll tell you this, you probably already know this at some level, that if you find people that know that you study law a little bit, they'll ask you things about family law cases. The other thing is they'll say they know more about it than maybe they do, and you can correct them at least, and maybe you can get them out of their own financial trouble that they're walking into if they make the wrong move in terms of their taxes. But you probably will be asked things. That's why this is class that I think is important. Hopefully, where you all are feeling we're getting some hands-on experience working through some of these problems. But tax really comes down to 3 things that you need to know. That spousal support is what we would call a taxable event. Okay, what does that mean? It means that the IRS is involved in some sense, meaning you put it on your on the form that you would file. Okay, spousal support is taxable. That means the payor, the person who pays spousal support, deducts it from their taxes, and the payee, the one that receives spousal support, has to put it on their taxes as income. So it's a deduction to the payor and a income to the payee. All right, that's important. Okay, now you see why the other 2 areas, people want to include those in spousal support because it's taxable. The other 2 areas are child support and property division, which really aren't a taxable event. Child support in particular. Child support has very little to do with tax. The only thing that you'll really ever see in child support about tax is that who is the parent for tax purposes, because there's a dependent deduction. In households where there are people make about the same, usually the child deduction, dependent deduction, is split year to year. Like all odd years it's mom, all even years it's dad. And the reason for that is because there's no good way to split it. In households that have one person makes a decent amount of more than the other, it'll probably always stay with the one because that's a more benefit to the family unit. Remembering it's about the children, it's not just about the parents. Okay, that's a good thing we want, but those are the ways those go. Sometimes if there's more than one kid, they'll be split between parents. There's all kinds of things like that. But really, other than that, child support isn't a taxable event in and of itself. So if I pay it to somebody, I don't get a benefit, I don't deduct it, and the person receiving it doesn't take it. They don't have to claim it as income, okay, for child support. Property division, that's the one that can be a little bit more complicated. We'll get to that in a second, but it has to do with when you transfer property to your now ex-spouse, there's an exemption for that. It can be a taxable event. Normally, when I sell you property, it's a taxable event. In a divorce, we try not to. It can still be, but there's an exemption for it. Okay, so let's talk about spousal support a little bit. Basically, you know the rule. The recipient has to pay tax on it, okay? And it's deducted from the gross income of the payor. And how do we know it's spousal support? Well, all of the 7 tests have to be met. What does it mean? It's part of a divorce or separation instrument. What does that mean? Either we have a separation agreement, we have a court-ordered separation, or we have a divorce order that creates that need to pay the spousal support. Okay, that's the first one. You do not file a joint return. What does that mean? You marry filing separately. You file married filing separately, right? Not a lot of people is that a benefit for. Depends. Some people, depending on usually high earners, when there's 2 high earners, it can be a benefit to them because I don't even know all the rules on that. But anyway, you can't file a joint return. Why? Because a joint return basically establishes that you're a single household, which is the next one. You're not members of the same household. Really doesn't apply if you're divorced because you can still live together if you're divorced, but you're not considered members of the same household, I suppose. You paid in cash as opposed to property, which means, not just in green. It has to be like a check or whatever. No payment after the death of recipient. That means you don't have to continue paying spousal support after you're dead or after the death of the person. That means it's not really support if you're already gone. That means it's something else. You're paying out what? Either child support or property division. You're paying out property. Okay, it can't be child support in disguise, and you can't exercise the option to not treat it as spousal support, and it can't be property division in disguise. So again, the big issues that come out have to do with trying to treat child support and include it in spousal support so you get a deduction. Okay, that's why you do it. Or you try to distribute property but call it spousal support so you get a deduction, because otherwise they're not taxable. Okay, a lot of times the biggest factor, and in the book you'll read that, you can read more about when child support is in disguise. It has to do with there are contingency factors related to child support. Okay, so if a child hits 18 and now all of a sudden spousal support is reduced, it looks like it's not spousal support, it looks like child support, right? There are factors like that that play in that make it look like really truly you're trying to pretend that child support is, you call it spousal support so you get the tax benefit. Okay? So the same can happen in property division. Be like, well, I owe you $50,000 to separate and make our equalization, so I'm going to pay you $500 a month, but until I pay off that money, we'll just call it spousal support, and then as soon as I pay it off, now your $1,500 payment goes to $1,000 because it's really contingency. Okay, so it's not really spousal support. Okay, why this all gets complicated is you can actually have spousal support that is tiered over time. Why do we know you can do that? Because you can have rehabilitative spousal support, reimbursement spousal support. They're not property division, they are support that can be tiered, right? That's why people get clever and do the things with child support and property division, because they can, because they do it in these other circumstances. Again, probably not really common. Okay, I gave you the key word being adjusted basis, but the property division has to do with it's not a taxable event. Okay, what does that mean? If I sell a piece of property, do I have to pay tax on it? Maybe, depending on how much I make when I sell it compared to what I paid for it. So what we call, I don't know if you all know much about tax, but I won't go into great detail, but basis is a tax term, very important in tax. Basis is the amount, generally speaking, the amount you pay for something. That's the value you have put into it. Okay? Any amount that is above that is income to you. Any amount that's below that is a loss to you for tax purposes. Okay? It's not realized until you sell it. So let's assume I buy a piece of real estate. Let's go back many years, and on Grand Central Avenue, I bought an acre of land right on what became Grand Central Avenue, right? Paid $10,000 for it. This year, I want to sell it, and it's worth who knows what, $1 million. Okay, what is my basis on that property? $10,000. If I sell it for $1 million and somebody gives me $1 million cash, about how much money do I have to pay in tax as income? $990,000 of income. Okay, so that 10%, 10,000 gets knocked off the top. Okay, you don't need to know this in great detail, but here's the benefit. What adjusted basis is that it is adjusted for things you contribute to it. The common example is in a house. You buy a house, and over time you put new windows in, a new roof. You keep all those receipts, so you pay $50,000 for a house. Over the next 30 years, you put another $50,000 in it. In dollars, you put them out, you keep the receipts. You now have something you put $100,000 into, and you sell it for $100,000. You have no gain. That's your adjusted basis. Okay. Why is that important? Well, it's not hugely important unless you don't make it incident to a divorce. It becomes a taxable event if it's not part of distribution in your divorce. Okay, then you would have to pay the difference between your basis and all this stuff. Anyway, it gets more complicated. So the point is, there's no taxable event as long as you're transferring it during your life or during your divorce process. Okay, you can deduct some legal fees and some of that stuff. That's kind of like almost inconsequential in most people's circumstances. You can only deduct fees for tax advice and to obtain alimony. You can actually bill separately. I don't know. You're not going to see that very often. The last thing I want to hit real quickly is that what happens when you signed a tax return while you were married, and now after the fact it's been audited and it turns out that it was something wrong with it, and you now owe back tax on it. And you were the innocent spouse. Okay? So you signed the return because your spouse was lied about the return. They're the ones who did it. They just set that down in front of you and said, sign this, it's ready to go, and they cheated on their taxes. What happens to you as the innocent spouse? Well, pretty much tough luck. That's what the IRS says. They have this process where you can get an exception that you prove you didn't know or have reason to know that they were understated. There are about 50,000 applications for that every year. They only grant just a fraction, maybe a third or so. Is that right? Yeah, somewhere around a third of them total will they pay. Will they grant some version of those? So in other words, you have to pay. That sucks, right? So your now ex-spouse who you're divorced from cheated on the taxes and now you owe it in what is called as joint and several liability. That means you owe all of the back tax yourself, and IRS doesn't care who it comes from. You can go get it from your ex-spouse if you want, but IRS doesn't care. They are not a party to the divorce. They don't care. 2 years ago when you cheated on your taxes, you're both responsible as far as they're concerned. And as long as they get it out of one, that's good with them. They'll move on. You can go sue your ex for that additional amount. Right?
What if you're separated?
If you file married filing separately, you're okay.
If you file jointly, then you're screwed.
Yeah, if you signed that baby, that tax return.
Even if you live separate.
Yeah,
But you file.
yeah. As far as the IRS is concerned, if you sign it together, you've also signed saying you agree to what it says. Yeah, not cool, huh? You can see a potential issue there. In other words, what they're saying is, be careful when you sign those. I don't know. I do my taxes at my house, and when I'm done with them, I give them to my wife and I say, here, sign here, but I always go over it with her first. And I always ask questions like, does that sound right? Does that sound like how much we made last year? It's not going to get me anywhere, but at least I can say, remember, I asked you every time.
CYA.
You got it. I am the lawyer in the family, so it only makes sense. Okay, any questions about that? I'm going to assign you an assignment. Oh, one last thing I wanted to mention is that Professor Turner and I are putting out a survey we want you guys to really fill out that is about like our program. And I'm going to put it in, I'll email it to you probably, or at least put it in the Blackboard somewhere so you can fill it out. It's a Google form. We won't know who you are, but you can only fill it out once, so the system will know you've only done it once. If you fill that out, it talks about the things that we're looking to do and what things you guys are interested in. If you participate in that, awesome. I'm going to put it in the assignment and say, hey, look at it at least. I'd really appreciate it if you fill it out, give us some ideas about things we can do. We want to keep growing the program and everything. We want to get everybody graduated too. So all right, good deal. But if you can do that, that'd be great. Okay, I'll share that with you. If you haven't already gotten it, he has it too. So okay, thanks. I appreciate it. Next week, assignment due. Okay. Bye.